Welcome. We got question 4 from July 2014. It's criminal procedure with a little bit of professional responsibility mixed in. Keep in mind, professional responsibility is the most heavily tested essay topic, so it's most likely to appear on the essay section. I mean, it's very likely to appear, almost about a 95% chance of that. And it crosses over with many different subjects. So crossing over with criminal procedure is nothing new. It doesn't happen very often. In fact, I don't recall another situation where that has happened, at least in the last 20 years. But PR does go with everything. Okay, so number 1, let's go to the call to question first. How should the court rule on each of Calvin's motions? Now notice that they're going to have to tell you what motions Calvin made, because if they're asking you to rule on them, they're going to give you the motion that he made. So if you go up 2 paragraphs, it says, Calvin filed motions for the following orders. So here's number 1. So this is part number 1. 1. Suppress the radio. Okay. Number 2, suppressing Dan's confession to Officer Query under Miranda for any use at trial. The word any, believe it or not, is what actually answers the call. So many people don't catch that. So it's Miranda, they tell you that. You know it's under Miranda. Confession for any use. Well, let me guess. A violation of Miranda. So if they don't give you Miranda warnings, if they don't, if the police officers interrogate you without reading Miranda warnings, or if they don't honor your right to remain silent or your request for counsel with the 14-day mark, then your statement cannot be used against you in the prosecution's case in chief. But you want to testify falsely, they can use it to impeach you. The violation of the police for Miranda does not give you a right to commit perjury. So 2 wrongs don't make a right, according to the justice system. Number 3, prohibiting Dan from testifying at trial. Dan, testify at trial. Okay, and call number 2, how should the court rule on Dan's request to represent himself? Dan represents himself. Okay. Well, since you're in court, we know we're going to have the 6th Amendment. Here, I see me on the street, there's the 4th Amendment. Miranda has to deal with the 5th Amendment. This has to do with prohibiting Dan from testifying in trial. It's because we're in court, 6th Amendment. So just the street jail court is really helpful in understanding what amendment's going to apply and what exactly it is you're going to discuss. Now, it doesn't fit neatly every single time, but it's a great rule of thumb and a good way to go about using it for broad strokes to kind of narrow the issues and exactly what you're supposed to be discussing. Okay. The call to question here, D's right to represent himself. Well, under the 6th Amendment, you have the right to counsel, and that means you have the right to counsel of your own choosing, provided it's not a public defender. If they appoint you counsel, you get who you get, period, at the end. You can't really, absent some kind of conflict or you can't get along with your attorney, the right to appointed counsel is not absolute. You can't start, I don't want this guy, and keep shuffling public defenders until you find someone who's actually going to listen to you. But you do have the right to get your own counsel of your choosing if you're going to pay for it. So part of the right of counsel is your right to choose. That includes the right to represent yourself. So there is a 6th Amendment right to represent yourself. It's also known as the right to shoot yourself in the foot. Because, as they say, anybody who represents themselves has a fool for a client. And that's what call number 2 is all about. All right, let's take it from the top here. One summer afternoon. Okay, why are the examiners going out of the way to tell us it's the summer? Generally in the summertime it's hot. In the wintertime it's cold. Except if you live in San Francisco, it's cold year-round. Officer Prowell saw Dan wearing a fully buttoned up heavy winter coat running down the street. All right, we're not here to, we can't actually view what's going on. I mean, is it crowded? Does it look like he's jogging? Does it look like he's trying to cut weight or doing it for some purpose? Does it look kind of suspicious, kind of shady? We don't know, but the officer, you kind of have to give the officer some kind of deference based on experience and training and the fact that the officer was there. But you have somebody running down the street, wearing a fully buttoned up heavy winter coat in the middle of summer. All right, Is that odd? It's a little odd. You could go either way on whether or not there is reasonable suspicion to stop to investigate. And that's what the first issue is. Well, we're going to get into is reasonable suspicion. Now, when the examiners test criminal procedure, in almost every case, they're going to have you do a discussion between reasonable suspicion or probable cause, and sometimes both. Because it's subjective, it requires an analysis, it requires use of the facts, and for you to fully explain what's going on, and it's a great way for the essays to test your skills as a lawyer. Now, the MBE cannot give this type of question because it's so borderline. That's what the essays are going to do. They're going to give you issues that you can't answer definitively so that there's a discussion. Notice the last word on every single essay is discuss. Yeah, I know community property will say answer according to California law, but right before it says discuss. They just want you to discuss it. Don't worry so much about the conclusion. Oftentimes, students will just want to write to a conclusion. Oh, what's the right answer? Sometimes there is no right answer, and there is no right answer here. I do think a touch better analysis, and I was actually on the other side before, but after reading the Horn books, the court would probably allow this under reasonable suspicion. So, criminal activity may be afoot. Activity may be afoot, and that means that you have specific and articulable facts to warrant a suspicion that criminal activity may be going on. Okay. So here we go. Officer Prowls ordered Dan to stop. Dan complied. Now that's a show of authority. That's a seizure. Show of authority. Okay? Now to order to seize somebody, that means to briefly detain them to investigate. Under a Terry stop, there has to be reasonable suspicion. Again, we've already went through the standard there. And a seizure occurs when an officer either grabs you, prevents you from going anywhere, pulls you over, checkpoint stops or seizures, traffic stops or seizures. A show of authority, which happened here, is a seizure once the defendant actually stops. Those are all different types of seizures, and they have to be based upon reasonable suspicion. So Dan complied as Officer Prowl began to pat down Dan's outer clothing. So if there is reasonable suspicion to seize, you actually have to ask yourself, does the officer have any reason to believe that Dan might be armed and dangerous? Because now we're talking about a pat down, and this leads to a Terry stop. Pat down, and that has to be solely for weapons. You can only pat someone down for weapons. So if the officer felt the bulge, that was a weapon, and they can tell from the plain feel without manipulating it that it is a weapon. I mean, guns are pretty easy to feel. Then they can, depending on if you're carrying it legally or whatever, it's just for officer safety. The whole point of a Terry stop is a pat down for weapons to ensure officer safety, to give the officer enough time to investigate what's going on, to make sure that either just let this person go, they're actually doing it for a very innocuous purpose, or it might raise the level to probable cause, therefore the officer might arrest you. So that's what the investigation is supposed to go. Do I let you go or do I have to arrest you? As Officer Prowl began to pat down Dan's outer clothing, a car radio, who in the world has a car radio, fell out from underneath. I can only imagine how long ago this essay was written. Now I know it was tested in July of 2014, but the essay could be 10, 20 years old. They have a whole bank of essays that they choose from. So, a car radio fell out from underneath. Officer Prowl arrested Dan and took him to the police station. Okay, well, pat down for weapons, and he's been arrested. So, is there probable cause to arrest? There is no warrant, so there has to be a warrantless exception. So the first thing we have is the seizure by the show of authority. That would be valid if it was based upon reasonable suspicion, which is questionable under these facts, and you could go either way on it. And then the Terry stop is a pat down for weapons, because the guy was running with a winter coat that was fully buttoned up in the middle of summer, and it is kind of suspicious, and people that are up to no good generally carry weapons. So that might give the officer a reason to believe that he might be armed and dangerous and to frisk him for weapons. Now, the probable cause to arrest, you have to have probable cause to arrest. One of the things that, like, well, the radio fell down, it says the car radio fell out, and he arrested him and took him to the police station. So, was that in plain view? So, did the officer have a right to be where he was? Because plain view requires the officer to be in a legal, in a place where he's legally allowed to be. He's on the street, totally fine to be there. So the lawful vantage point is taken care of. Now, is the radio, is it immediately apparent that it is evidence of a crime or contraband? I mean, it's just a car radio. How would you know whether or not it's stolen? You have no idea. Believe it or not, a lot of people kind of oversaw that. They're like, oh yeah, he stole the radio, it fell out. And what the officer could have done before arresting him, because don't forget, we have arrest. You need probable cause to arrest or a warrant. And the officer is going to claim that, hey, the reason I arrested him without a warrant is because I saw the radio, I knew it was contraband, it was evidence of a crime, and therefore I arrested him. Well, how did you know that? It wasn't immediately apparent. You'd have to run the serial number, you'd have to do something in order to find it. You can't just look at it and go, yep, that's a stolen radio. How would you know? You would have no reason to know that, so it wasn't immediately apparent. And a good answer would have caught that. Okay? So that first paragraph goes to call 1-1, part 1 with the suppressing of the radio. All right. The next paragraph. At the police station. So now we're in custody. Fifth Amendment, Miranda is going to apply. We're at the jail. Because remember, 4th is street, 5th is jail, 6th is court. Officer Query met with Dan and began asking him questions about the radio. Okay, well, you're in custody and now you're being interrogated. So that's a violation of Miranda. You need to read Miranda rights. And of course, they even tell you the issue is Miranda. It's clearly an interrogation, which is likely to elicit a incriminating response. And he's in custody. He's at the station house. He's been arrested. I think he was in handcuffs. Doesn't say. But he's not free to leave. He's not going anywhere. Therefore, Miranda warnings needed to be administered. Dan stated he did not want to talk. So even if they did administer Miranda, which they didn't, he's already exercised his right to remain silent, which they have to scrupulously honor. So once he exercises his right to remain silent, they have to stop questioning him for a while. Officer Query responded that if Dan chose to remain silent, he could not tell the district attorney that Dan was cooperative. Dan immediately confessed that he stole the radio. Okay, so they're kind of maybe, that's not objectionable. That doesn't make it involuntary. And we'll get into that in a second. So Dan immediately confessed. Well, that confession is clearly in violation of Miranda. No Miranda warnings were issued. He was in custody. He was being interrogated. And he expressly invoked his right to remain silent. And by the way, that is the standard. In fact, that was actually a right answer choice on the MBEs very recently, where the answer was express invocation. So, based on recent Supreme Court precedent, you have to expressly invoke your right to remain silent. It's kind of contradictory because you can't just sit there and remain silent to exercise your right to remain silent. You actually have to speak to exercise your right to remain silent, which is kind of interesting. And the dissent had a field day with that. So in order to properly assert your Fifth Amendment right to remain silent under Miranda, you have to expressly invoke it by saying, I want to remain silent. Now, you could just sit there and be silent the whole time. They're just going to keep badgering you until you say something. And that's exactly what happened in the case. Just say, I don't want to talk to you, I want my lawyer. And that's how things should go. Okay, so he confessed. So his confession cannot be used in the prosecution's case in chief. But as we later find out, he plans to testify at trial that he did not steal it. So he's going to lie. He's intending to commit perjury, and they could use it for impeachment. Because they're asking whether or not the confession, it says here, suppresses confession under Miranda for any use at trial. Can't use it in the prosecution's case in chief, can use it to impeach. That word any, I'm telling you, paying attention to detail and the facts that they give you in a call of the question and reading it carefully is so important. I can't stress it enough. All right, so again, he was interrogated, custody, right to remain silent, expressly invoked it. They can use it to impeach. One little ancillary matter on question 1.2, if you will, is that if you can prove that the confession was involuntary, it cannot be used for any purpose whatsoever, not even to impeach. But that is extremely rare. In order to have an actual involuntary confession, they have to literally be beating the crap out of you. They have to threaten you. They have to beat you. That's not what happened here. In fact, there's a case back in the 1930s where a defendant was hanged, beaten, whipped, stripped naked for days until he confessed. That's the definition of involuntary. And the fact that he told the prosecution that he was cooperative, they wouldn't tell him he was cooperative. He's not making any promises or guarantees or if he confessed, so that's actually not objectionable. Okay. Dan was later charged with larceny. He retained Calvin as an attorney. He told Calvin that he was going to testify falsely at trial, that the radio had been given to him as a gift. Well, clearly that contradicts his statement to Officer Query, where he said he stole the radio. There's the impeachment. Calvin informed Dan that he would make sure he never testified. Well, fortunately, Calvin, and it says for call number 3, 1.3, Calvin filed the motion to prohibit Dan from testifying at trial. So his own lawyer is trying to prevent him from testifying. Well, can he? The answer is absolutely not. You have a Sixth Amendment right to testify. And no attorney can stop you. Don't forget, the PR rules are federal law, but the Constitution is supreme and it trumps federal law. So the Sixth Amendment right to testify, right to a fair trial, right to present a defense, that's the defendant's constitutional right, and nobody can actually stop him. So he does have the right to testify. And what should the attorney do? So the attorney, while is powerless to prevent him from testifying falsely, under the ethical rules, under the ABA, he should persuade Dan not to testify falsely. Calvin should talk to Dan about it and say, hey, you shouldn't testify falsely. If you do, I'll withdraw because I can't be part of that. Under California, you just let him go on the stand and do narrative. You just ask him a few questions and you let him go, and this signifies to the judge that I don't want to be involved in this. I'm not going to ask him any questions. He'll just tell a story. We all know he's lying. Okay, but the attorney cannot stop a criminal defendant from testifying. At a hearing on the motions, a week before trial, notice the time, a week before trial. This is the second time the examiners have done something like that, where it's a week before trial and bringing up the timeliness of the motion. Dan, in response to Calvin's motion for an order prohibiting him from testifying, stated, I want to represent myself. And you do have the right to represent yourself. And that's actually part of the right to counsel of choice, including the right to represent yourself, also known as the right to shoot yourself in the foot. So, it says, how should the court rule on Dan's request to represent himself? Okay, in order to represent yourself, you must be competent. All right? There are two levels of competency. There's competency to stand trial, which is such a low standard. If you're a drooling vegetable that can just sit in a chair, you're competent to stand trial. That's all. I mean, it is such a low standard. Now, competent to represent yourself is, according to the Supreme Court, recent case law in 2008, stated that the right to represent yourself is a higher standard. It's not much higher, but it is higher. And what that includes is you have to understand the nature of the proceedings against you. You have to have the understanding of how to present a defense. Now, you don't need any legal knowledge, but you just have to understand what's going on and be able to have the ability to put on some type of defense. Okay, now, in order to represent yourself, which is a Sixth Amendment right, and it's structural error, if the court improperly denies you that right, it's an automatic reversal of your conviction if you get convicted. And by the way, when you do represent yourself, you can't claim ineffective assistance of counsel because you're the one who chose to represent yourself. So here, the motion must be timely. And we have 1 week before trial, so if there's possible prejudice, you have to look at it. But here, it's not like Dan's making this motion to kind of hope a witness dies or mess with the prosecution's case. It seems like he's got a legitimate beef with his attorney. I mean, his attorney's trying not to put him on the stand. That to me would leave a bad taste in my mouth, and I think the court should probably grant it, even though it's 1 week before trial, because don't forget, Dan's gonna need time to prepare. He's gonna need, and that's gonna have to postpone the trial, it's gonna delay the court proceedings. Witnesses are already scheduled to be there, they have the courtroom reserved. This absolutely hurts judicial efficiency, and that's why it has to be timely, because the prejudice is there. But nevertheless, even though you have the right to represent yourself, the courts may still appoint advisory counsel. And by the way, not too many people know this. This is a very esoteric issue. It's extremely unique. It's not tested heavily at all. In fact, it is extremely rare. I mean, extremely rare. So if you don't know any of this, don't beat yourself up. Not too many people did. So they can appoint it, and the court may appoint advisory counsel, and all they're going to do is just help you with the routine procedures, explain to you some of the things that are going on, so the judge doesn't have to sit there and tell you about all those things. It kind of just relieves the judge's burden, but the advisory counsel is not allowed to make any strategic decisions. They can advise you about what evidence you should put on or what witnesses you should call, but ultimately that's the defendant's responsibility if he chooses to represent himself. Okay? So that's it. Very common issues up until these two, which are a little bit rare. Don't forget it. An attorney cannot stop a criminal defendant from testifying, and a criminal defendant has the right to represent himself. That's the counsel of his choice, so long as he's competent and the motion is timely. And that's pretty much it. That's the wrap for July 2014 Criminal Procedure and PR. Thanks.